Welcome to The Fine Print, the podcast where we explore the law, its impact, and the people who shape it. I'm your host, Riddell, and today I'm delighted to welcome Miss Kaylee Karam, a lawyer specializing in wills and estates. She's completed her double degree in law and arts at La Trobe University and now practices at Burns and Tinney Lawyers in Greensboro, Victoria, guiding families through estate planning and deceased estates with clarity, compassion, and a client-focused approach. Her volunteer work with the Whittlesea Community Legal Service Wills Clinic and Blind Sports Victoria has further shaped the empathy she brings to her practice, helping make succession planning accessible and clear to her clients, guided by genuine care and support for them. So, to start us off, how did your journey into will and estates law begin?
Thank you very much for that introduction, Riddell. And I'm very grateful that you have invited me to speak on your podcast. As I said, I think it's a really amazing initiative that you've started. So to start off, I didn't really see myself in wills and estates when I first started law. It was definitely not something I expected. It's not the most glamorous area. For a lot of people, their perception of it is that it's quite boring and a bit morbid because I'm often dealing with talking about death. It wasn't something that I set out to do. So my very first job was actually as a retail assistant working at a toy store called Toys R Us, which is probably the least legal job that you can imagine. But it actually helped shape the law that I decided to work in, because as a retail assistant, you're dealing with people from all walks of life. You have to help them solve problems and put them at ease when they were stressed. So I then realized that was quite a strength of mine, that I liked talking to people and helping solve their problems. And then later I volunteered at a wills and estates clinic. So that was whilst I was still studying law at university. And the Wills and Estates Clinic is a service where people can have wills and estate planning documents drafted for them if they can't afford to pay a lawyer to do them for them. So when I did that, I felt a real sense of purpose, like I was helping people, and I could see a tangible way forward as to the sort of law that I actually wanted to do, which was working closely with clients. And that's definitely what you do in this area with wills and estates.
Wow. Thank you so much for sharing your journey and how you got interested in this field of law. From learning about your qualities by being a kind of empathetic person in your retail job and then transferring those skills into the law that you do today. Mm-hmm. So I'm curious, what factors typically cause a will to be challenged?
So in my experience, there's two different sorts of challenges to a will. The first type is where people are challenging the validity of the will, so challenging whether the document that was made is actually valid. And so that can arise where the person who made the will has a cognitive decline or disease at the time of making the will. So an example would be if they had dementia or Alzheimer's. Another example where there could be an issue with validity of the will is there could be undue influence or suspicious circumstances around the time the will was made. Sometimes that arises with adult children. They might be well-meaning and trying to help their parent by setting up the appointment for them to make a will. But then if that parent goes ahead and gives more to that child than their other children, that's where their siblings, once the parent has passed away, might then challenge the validity of the will, as there's few red flags there saying, well, you've helped mum or dad prepare the will. We think that you influence them to make the will. So that's one sort of challenge to a will, challenging the validity of the document. Then the other more common challenge that I see is not actually challenging whether or not the will is valid, but more so challenging if what they've been left in the will is sufficient for their financial needs. So if they've been left anything at all, sometimes people fully leave out beneficiaries from the will. And not just anyone can challenge a will. In Australia, and mostly I'm speaking from my state in Victoria, which I'm sure a lot of the law overlaps in Australia, there are only a few people that can challenge a will. So a spouse is one of them, a child, or a financial dependent. And if those people have been left out of the will or have been left less than they expected, then it's more likely that they will challenge what they have been left in the will, so make a claim on the estate. Yeah, those are the two different sorts that I see quite often.
Firstly, I didn't even expect that, having a mental kind of condition or disability would influence a will in this circumstance. And especially these two different types, they're so distinct, yet you have broken them down very well. So, what happens to a will if someone dies without it in the jurisdiction?
So in Australia, if someone dies without a will, and particularly again in Victoria, so just flagging all of my experience comes very specifically from my state, but from my jurisdiction, as you said, if someone dies without a will, it means that they've died intestate. And so it's just another way of saying legally that they died without a will. And what happens then is the law steps in and sets out strict rules about who inherits what and in what proportions. So sometimes that works out for people, as in, let's say if a person passes away and they had a surviving spouse that they would have wanted to receive everything anyway. And if they died without a will, that spouse would actually receive from the estate. And so in that circumstance, it's okay. Where it becomes more complicated is when we've got blended families, so people that have stepchildren or second marriages, children from a prior relationship, that sort of thing. The law sets out how the estate is distributed, and it might not be exactly how that person would have wanted. So it means that the person loses their voice. They don't get a say. It's the law that specifies how the estate is distributed. I've had recently a few circumstances where there've been adult children that have passed away without leaving a will, and they probably just put it at the back of their mind, didn't think it was an important thing to do. But now their parents are actually inheriting from their estate because that adult child didn't leave a partner or any children. And I mean, we can't say whether or not that's what they would have wanted because they've unfortunately passed away. But it might have been that they would have preferred to leave their estate to a niece or a nephew and not have their estate distributed in accordance with what the law has said. So
Yeah, what a valuable insight. And I think you've put that really expertly on how they just kind of lose their voice and how they're unable to kind of decide what goes to who, and it's just decided by the law. So, moving on, what is a misconception in this field that you wish more clients understood?
I think going back to your previous question about dying without a will and how it can be quite tragic if an adult child dies without a will and their estate goes to their parents. I think a common misconception is that making a will is only important if you're older or if you have children or if you have significant assets. In my view, making a will is important for anyone that's over the age of 18. As long as you have some sort of asset, bank accounts, most people can say that they do have an asset that would form part of their estate. I think that it is important to put in place a will because if the unexpected were to happen, at least you are setting out a set plan for your family during a time when they might already be quite stressed. Another misconception that does tie back again to dying without a will is people also seem to think that if you don't put in place a will, then the government would take everything. So that's not necessarily true. It would be very unlikely for the government to get any of your estate. You would basically have to not have any surviving family. So as much as I think a will is important, I don't want people to catastrophize and think that the government will take everything if they don't put in place a will. Probably one other thing I would like to add is that people think that estate planning is just making a will, where there's actually other documents that are maybe as important or more important than making a will called powers of attorney. And powers of attorney set out who you want to make financial, personal, and medical decisions in the event that you lost mental capacity. So that could be dementia, that could be an acquired brain injury, anything of that nature that might affect your capacity to make decisions. It's very important to put in place who you would want to be able to access your bank accounts, as an example, or speak to the hospital and medical staff. I think that a lot of people overlook those documents thinking they're not important. I think they're just as important or even more important than making a will.
That's so true. I can definitely see how these kinds of different factors may be misunderstood, especially having this kind of assumption that will should be only created after a certain age or a certain time, and kind of the assumption that, oh, yes, the government will take all my assets if I don't create a will in time. So, on a related note, what are some ethical challenges that may arise in this process, and how do you manage them?
Well, my client base, often I'm assisting elderly clients, and one of the biggest ethical challenges for me is balancing the legal tests that we have to have as lawyers as to whether or not these clients have capacity to make a will, and balancing also wanting to acknowledge and honor a client's intentions to make a will. Sometimes it's a difficult balancing act because I don't want to ever assume that because someone's of a certain age that they immediately don't have capacity. So at the firm where I work, we don't automatically ask for a medical certificate before we meet with elderly clients. Whereas I know some law firms, if a client's over the age of 75, they sort of operate on the assumption that the person might not have capacity, and they will not make a will for that person unless they've seen a medical certificate saying that the person does have a capacity. So our firm doesn't operate in that way, and I don't operate in that way. I make the decision myself, which is what we are supposed to do as lawyers. But it can be difficult if someone has been, for example, recently diagnosed with dementia. They might then realize that it's really important for them to make a will, and they'll want to quickly do that. But I have to make sure that they understand the document that they're putting in place. And that can be tricky and can cause delays whilst I'm trying to work out whether or not they do understand the will. So that's definitely an ethical challenge. And I think a reminder for people to not wait until you've received a diagnosis of dementia or until you're in your late 70s, 80s, 90s before making a will, because you can make it more difficult on yourself and on your lawyer to actually put in place the document.
Your experience, really shows in this explanation of this ethical challenge and kind of assessing whether someone has a mental capacity to create a will at this certain age. So, looking at the field overall, have you noticed any trend shifts in the way clients plan their wills and estates?
I think clients are actually more educated and knowledgeable, given that now we are in an era where information is so readily available. People do use AI, and sometimes it can be helpful for them to get a background before they speak to me. So I would always say it's never a replacement for legal advice, but I have noticed it's resulting in clients being more informed about their estate planning and the importance of their estate planning. One example of that is people are more curious as to putting in place wills that aren't just standard wills and testamentary trust wills, wills where you're not leaving the inheritance to the beneficiary in their personal name. You are actually leaving inheritance through a trust, and that can have tax benefits and asset protection benefits. So I'm noticing that sometimes without prompting, more clients are actually asking for those sorts of wills because they are more educated in this area. Also, with the rise of blended families, obviously that has been a trend that has started since before I was practicing law, as in divorce has become more acceptable in history. So blended families are becoming more and more common, where more care and nuance is required to make sure that everyone's needs are met and that the client's wishes are fulfilled. So more education into estate planning, and I think more care being needed into clients' estate planning. We're not just seeing mum and dad with two children. There are more complex family dynamics that I have to take into account these days.
You've provided a really meaningful perspective and just kind of evaluating and observing these trend shifts over time and how people are just, as you mentioned, becoming more educated, yet you also see the rise of more societal norms taking into place with blended families and divorce, etc. So, kind of adding on to that, in your experience, what is the most effective way to prevent future litigation between family members?
One tip I will give that is entirely free is to actually just be open and honest with your family as to how you have set out your will or what your wishes are. Sometimes people are more likely to make a claim if there's an element of surprise in the will of the deceased, if there's something in there that they didn't expect or they didn't know, or if there was something that wasn't talked about. So an example would be burial and cremation wishes or wishes around funerals, that sort of thing. If the person never spoke to their family about what their wishes were in that regard, there can be really significant arguments about where the person is to be buried. No, that person wanted to be cremated. It's people trying to speak for the wishes of someone who's no longer there, and that can increase the risk of a dispute. So the inverse of that would be for the person who's made the will to actually just discuss openly and honestly, even if it's about topics that are quite difficult to talk about. You may be doing your family and your estate a favor by just being honest as to how you want your estate distributed and what your wishes are. And it can be a really difficult conversation in that you might actually be leaving out one of your children in the will, and that is a really difficult thing to talk to them about. But my view is that gives that person more time to come to terms with the fact that they've been left out of the will or that you're planning on leaving them out of the will, and might reduce the risk of them making a claim against the estate and respecting your wishes.
I love how you just broke that down and just talking about the nuance between family members and how sometimes wills may come as a surprise to them, causing them to react in certain ways, as you mentioned. And I think, kind of on that note, and similarly, we spoke a bit about people not having a voice and how their voice might be limited. So, what steps do you take to ensure that a will is free from undue influence?
One of the most important things that I have to be satisfied on is that the instructions of the person making the will aren't influenced by anyone else. So, what I will do in that circumstance is, again, you might have a well meaning adult child who might want to help their parent, and that's fine. They can call us up, they can call the law firm and make the appointment for them. They might help them with filling out some of the instructions. But we would never rely fully on anything that's been typed out previously. We would always meet with the client on their own. We would have to say to the adult children, and this can be a bit difficult, but we'd have to say to the adult children in this example, sorry, we're just going to steal your parent away for a little bit just so that we can have a discussion with them and ensure that their instructions are not being influenced by any person. And I also make sure that I take very detailed file notes as to the person's wishes. And I say to them that it doesn't matter what your children or family want you to do. Your will is about what your wishes are and what your instructions are. So really letting them know that they don't need to make a decision based on any pressure from any family members. It's not a popularity contest. They don't have to have everyone appointed as executors if that's not what they want. As an example, just really ensuring that I'm hearing the voice of the person who is making the will and not listening to outside influence.
Yeah, I think that's so important. Just having that one-on-one communication with the client and the lawyer just ensures this kind of privacy and allows them to talk freely, as you mentioned, and make their own decisions.
Mm-hmm.
So, something a bit about your job as a whole. What do you feel is the most fulfilling part or parts of practicing in this legal specialization?
One of the most fulfilling parts for me is that I feel like I can be a safe haven for clients that are going through what might be a really difficult, confusing, or they might a confusing time, or they might even be in a state of grieving. It just depends where I am meeting them in the journey of estates, because I could be meeting them making their will, and I could be helping them once, in another example, once someone's parents have passed away and they're trying to deal with the estate. So I like helping people navigate this area of law, which can be quite technical and complex. I like being able to explain it to people in plain English. And one of the most rewarding aspects of my job. And the biggest compliment that I could receive is when someone says that they had thought this whole process would be a lot scarier than what it was, and that I made them feel like they could understand the process and that they were comfortable with me and that it wasn't as scary as they initially had perceived.
That's so inspiring. Just making this field more accessible and clear for natural people and people who are going through this process, might be in a time of, grieving or mourning, and you're just here to make this process a lot simpler, I think is something so beautiful. So finally, what advice would you give to someone wanting to specialize in wills and estates law?
One of the most important things I think to hone your skills on would be your communication skills and your ability to listen to people with empathy, because sometimes I do feel like, even though I have no qualification to be a therapist, sometimes I do have to almost act as a part therapist and full-time lawyer as well. So you have to be able to hear what people are saying and really understand it and feel a sense of empathy. This area of law doesn't reward people that are wanting to work in a really quick snap, fast, numbers-driven area. It's very personalized and it's a very human area of law. I guess on the flip side of that, whilst it is a very human area of law and you need to be good with your communication skills and people skills, I think it's also very important to really hone in your attention to detail. That is one thing that, unfortunately, when you're drafting a will, if you do make a small error, which we all do, it can be quite detrimental and possibly devastating to the will itself. It might mean that the will is no longer valid just from a small mistake. So I would say it is very important to try and work on your attention to detail, but very important to build your people skills. I also think that as important as university is, in this specific area of law, it would be great for people to try and get practical experience as early as possible. So volunteering for things like the Wills and Estates Clinic that I mentioned earlier, or even if you get some office experience, because you will need to speak with people on a daily basis and you need to get really good at dealing with people from all walks of life.
Those are some really insightful pieces of advice, and especially just developing that sense of empathy. I think it definitely ties back to all your volunteer work that you've done and your experience as a whole, and really highlights, the specialization and the nuance of human skills and interpersonal skills that you need to kind of excel in this field. So thank you so much for your time, Ms. Karam. And to all my listeners, court is now adjourned until next time with the fine print.